Avoid probate nightmares, the 12 estate planning mistakes that cost families thousands. A 20-minute podcast script. Introduction. Hello and welcome. I'm so glad you're here because what we're about to discuss today could literally save your family thousands or even hundreds of thousands of dollars in unnecessary legal fees, court costs, and heartache. We're talking about one of the topics most families avoid until it's too late: estate planning and probate. If you're listening right now, there's probably a reason. Maybe you've lost a loved one and watched the family get tangled up in a costly probate process. Or maybe you're realizing that you have no idea what happens to your assets when you pass away. Or perhaps you're simply tired of feeling anxious about leaving a mess behind for the people you love most. Here's the truth. Estate planning isn't depressing or morbid. It's actually one of the most loving things you can do for your family. When you plan ahead, you're essentially saying, I care about you so much that I'm going to make this easier on you. Today, we're going to walk through 12 critical mistakes that cost families thousands, and more importantly, how to avoid every single one. Let's dive in. 1. What happens to your assets when you die? Let's start with the foundation. When someone passes away, every single asset they owned takes one of three paths. Understanding these three paths is absolutely critical to everything else we discuss today. Path 1, the asset goes through probate. This is the public court process where a judge decides what happens to your things. It's slow, it's expensive, and it's public, meaning anyone can go to the courthouse and see exactly what you owned and who you left it to. Path 2, the asset passes through contract. This might sound fancy, but it's actually quite elegant. Certain assets like your retirement accounts, life insurance policies, and payable on death bank accounts have a built-in mechanism. They're set up to go directly to whoever you named as a beneficiary. No court needed. No delays, no public record. Path 3, the asset passes by operation of law through ownership. This is where joint ownership comes in. If you own property jointly with right of survivorship, it automatically passes to the surviving owner the moment you pass away. Again, no court involved. The million-dollar question isn't which path is best, it's whether you're deliberately choosing your path or whether you're leaving it up to chance. Most families do the latter, and that's where the mistakes begin. 2, the easy route, avoiding probate. Here's the beautiful part about paths 2 and 3. They bypass probate entirely. And when I say bypass probate, I mean your assets transfer automatically to the people you want them to go to, often within days or weeks instead of months or years. No court hearings, no delays, no strangers knowing your business. The key tools for avoiding probate are so simple, you'll wonder why we don't teach this in school. First, there are beneficiary designations. When you name a beneficiary on your retirement accounts, your 401k, your IRA, your 403b, you're essentially creating a contract that says, when I die, this money goes directly to my daughter, or this goes to my grandchildren. No probate, no lawyers, the financial institution handles it. Second, there's the transfer on death deed, sometimes called a TOD deed. This is a magical little document that lets you say, when I pass away, my house goes to my children. Without probate, you keep full control during your life. You can sell it, refinance it, do whatever you want. It only kicks in when you're gone. Third, there's the revocable trust, and this is huge. A revocable trust is essentially a legal container that holds your assets. When you pass away, those assets don't go through probate. They go to whoever you named in the trust. Your family avoids probate, saves months of waiting, and keeps everything private. The bottom line, assets transfer automatically to the people you choose, not to the state, not to the courts, not to strangers in probate, to your family. That's the power of proactive planning. 3, Joint ownership makes a difference. Let's talk about one of the most misunderstood tools in estate planning, joint ownership. Many people think that adding someone's name to their house title is a good estate plan. See? They think, when I die, my house automatically goes to them because we're joint owners. But here's where people get into trouble. There are different types of joint ownership, and they have very different consequences. Joint tenancy with right of survivorship, that's the good one. When you own property this way, it does pass directly to the surviving owner when you die. The home bypasses probate. Your family can stay in the house, deeds get transferred smoothly. This is what most people think they have. But joint ownership also creates some real problems you need to know about. First, if your joint owner gets sued, both of your interests in the property could be at risk. That liability flows both directions. Second, if you want to sell or refinance, you both have to agree. You've essentially given someone else a legal veto on your own home. Third, and this is crucial, joint ownership doesn't work well for blended families. If you remarry and put your new spouse's name on the deed, you might unintentionally disinherit your children from your first marriage. Bottom line, joint ownership with right of survivorship works great in some situations, but it's not a complete estate plan, and it can create unexpected problems. That's why most estate planners recommend the transfer on death deed or a trust instead. They give you the same probate avoidance benefit without the liability and control issues. 4, the trust that protects everything. Now let's talk about the superstar of estate planning, the revocable living trust. This is probably the most powerful tool available to protect your family, and I want you to understand exactly what it does. A revocable living trust is a legal document that creates a container, a vessel, if you will, that holds your assets. You create the trust during your lifetime. You put your home, your bank accounts, your investments, your personal property, whatever you want, into the trust name. You name yourself as the trustee, meaning you're in charge. So your life doesn't change at all. You still pay the mortgage. You still write the checks. You still live in your house. It's all the same. But here's where the magic happens. When you pass away, you've already named a successor trustee. Maybe that's your daughter. Maybe it's a professional trustee. That successor trustee steps in and distributes everything in the trust to your beneficiaries. No probate, no court involvement, no delays, just a smooth private transfer from you to the people you love. And there's a bonus. If you become incapacitated during your life, if you have a stroke or develop dementia, your successor trustee can step in and manage your affairs for you. You've essentially created a safety net that works in two directions, after your death and during a disability. The reason it's called a revocable trust is because you can change it anytime you want. You're not locked in. You can add assets, remove assets, change beneficiaries, modify terms, whatever you need to do. It's flexible and responsive to your life. Compare that to a will, which you can only change by redoing the whole thing. A living trust keeps your affairs private and in control. Your family members and successor trustee know what to do. There's no confusion, there's no conflict, there's just a clear roadmap. That peace of mind is priceless. 5, when a valid will saves time and stress. You might be thinking, wait, Lisa, I thought we were trying to avoid probate. Why do I need a will if I have a trust? Great question. The answer is that a will and a trust serve different and complementary purposes. A will is a legal document that accomplishes several critical things. First, it names your executor, the person responsible for administering your estate and carrying out your wishes. This person will handle your final affairs, pay your bills, file your tax returns, and distribute assets according to your instructions. Second, a will allows you to name a guardian for your minor children. If something happens to you before your kids reach adulthood, your will says, I want my sister Sarah to raise my children, not whoever the court decides. That's enormously important and something no parent should leave to chance. Third, a valid will makes the probate process faster and smoother. Yes, you'll still go through probate for assets not in a trust, but having a clear, properly executed will prevent family conflict, eliminates delays, and ensures a court-supervised process that protects everyone involved. Fourth, if you have a will and a trust, which is the best practice, they work together beautifully, most of your assets avoid probate through the trust. But any assets that weren't titled to the trust or any new assets you acquire go through a quick probate process governed by your will. That's called filling the gaps. A valid will signed by you and 2 witnesses creates a legal roadmap for your executor. It prevents your family from guessing about your wishes. It saves time, stress, and often tens of thousands of dollars in unnecessary litigation. Never underestimate the power of a properly drafted will. 6, the pour-over will, the safety net most families forget. Now, here's a concept that separates a good estate plan from a truly comprehensive one, the pour-over will. And I'm going to tell you, this is the detail that catches most families off guard. Imagine this scenario. You have a revocable living trust. You've put your house in it, your bank accounts, most of your major assets. But let's say you acquire a new investment property right before you pass away, and in the rush, you never retitled it to the trust. Or maybe your car is titled in your personal name. Or maybe you receive an inheritance from a family member just weeks before you die, and it comes in as a check to John Smith, not John Smith, as trustee of the Smith Family Trust. These are called assets not in the trust. Without a plan, they go through probate anyway. Your family has the expensive, time-consuming court process for those assets, even though you tried so hard to avoid it. That's where the pour-over will comes in. It's specifically designed to catch any assets you forgot to transfer to the trust. The will says any assets not already in my trust should be poured into the trust and distributed according to its terms. It's like a safety net. It's not elegant. Those assets still technically go through probate, but they end up being distributed according to your trust document, which is comprehensive and private. Think of a pour-over will as the ultimate insurance policy. It ensures that no matter what slips through the cracks, everything eventually flows into your trust and out to your beneficiaries according to your exact wishes. It's the difference between I hope I got everything right and I know everything's covered. 7, no will, no plan, big problems. Let's get real for a second. If you die without a will, what's called dying intestate, your estate steps in and makes all the decisions. Not you, not your family, the state. And the state's plan is probably not your plan. Here's what happens. A court-appointed administrator, sometimes called a public administrator, takes over. Your estate goes through full probate. The court-supervised process, the public court records, the months and months of waiting, and everyone, the judge, the lawyers, the creditors, anyone who searches the courthouse knows exactly what you owned and where it went. But it gets worse. State law determines who gets what. In many states, if you're married with children, your spouse might get 1/3 and your children split the remaining 2/3. Is that what you want? Or maybe you wanted everything to go to your spouse. Too bad. State law says no. Your adult children, even if they're millionaires, get a piece of your estate whether you want them to or not. No will means state intestacy rules apply, family conflict erupts, delays multiply, costs skyrocket. And if you have minor children, without naming a guardian in a will, the court decides who raises them. Maybe the court chooses a family member you never would have chosen. Maybe they choose someone the kids don't even know well. You've given away one of the most important decisions of your life. The message here is simple and stark. No will, no plan, big problems. A will doesn't have to be complicated, and it doesn't have to be expensive, but it has to exist. It's non-negotiable. 8, when the court must decide, now let's zoom in on what happens when the court must decide your family's future. And believe me, this is not something you want to experience. When you die without a plan or with an incomplete plan, the probate court assigns someone to be your administrator. This person has to go to court, file papers, wait for court dates, get court approval for everything, selling your house, paying your debts, distributing assets. Every single action requires court supervision and approval. It's expensive, it's time-consuming, and it's completely avoidable. Here's what it costs your family. Money, obviously, attorney's fees, court filing fees, executor fees, probate appraiser fees. In some states, probate costs can eat up 3 to 7% of your entire estate. If your estate is worth $500,000, that's $15,000 to $35,000 in unnecessary costs. If it's worth $1 million, that's $30,000 to $70,000. And that money doesn't go to your family. It goes to lawyers and courts. But the real cost isn't just money, it's time. Probate typically takes 6 to 12 months, but it can drag on for years if there's any dispute. Your family can't access their inheritance. Your house can't be sold. Your car sits in the driveway. Meanwhile, your heirs are paying taxes on assets they don't have access to yet. The stress, the uncertainty, the grief compounds month after month, and that's the best case scenario when there's no conflict. If your family disagrees about your will or questions the administrator's decisions, the court has to settle those disputes. Heirs fight heirs. Siblings sue siblings. Attorneys make money. Your estate gets smaller, and your family relationships, some of which took decades to build, get destroyed in months. Without a plan, the court decides. With a plan, you decide. That's the difference. 9, review your beneficiaries. Here's something most people don't think about, and it's absolutely critical. Your beneficiary designations. Remember when we talked about retirement accounts, life insurance, and payable on death accounts? How they pass automatically to whoever you name as beneficiary? Well, that's only true if you actually named a beneficiary. And even if you did, you need to revisit those designations regularly. Think about your own life. When you opened your 401k20 years ago, maybe you named your parents as beneficiary. Well, you're probably married now with kids. You've got new priorities. But if you haven't updated that beneficiary designation, when you pass away, your entire 401k goes to your parents instead of your spouse and children. That wasn't your intention, but that's what the paperwork says. And the financial institution has to honor the paperwork, not your intentions. Or here's another scenario. You go through a divorce, but you forget to change the life insurance beneficiary. Your ex-spouse gets $500,000 when you pass away. Your current spouse gets nothing, your kids get nothing, and there's nothing your family can do about it because the policy says what it says. That's why every couple of years or whenever something major changes in your life, you need to review your retirement accounts, your life insurance, your bank account designations, and make sure the beneficiaries are correct. After a marriage, after a divorce, after your kids are born, after a promotion, when your net worth changes, these are trigger events. You pull out the beneficiary paperwork and you update it. One signature today can prevent massive family conflict and incorrect distribution of your assets. That's the power of reviewing your beneficiaries. 10, fund your trust. Use it or lose it. Now, this is where I see people make a huge mistake, and it costs them everything. They spend money on a beautiful, comprehensive, revocable living trust. The document is perfect. It names their beneficiaries. It names a successor trustee. It's thorough and detailed. And then they never put any assets into it. It's like buying a house, never moving in, and expecting to live there. The trust is just paper if you don't fund it. Funding a trust means retitling your assets in the trust name. Your house goes from John Smith to John Smith, trustee of the Smith Family Trust. Your investment accounts get retitled to the trust. Your bank accounts transfer to the trust. This is the actual work of estate planning. The document is just the blueprint. Funding is the construction. And here's the beauty of doing it. Every dollar in that trust avoids probate when you pass away. That money goes directly to your family. Every piece of real estate in that trust passes outside of probate. Every investment account in that trust bypasses the courts. But if you don't fund your trust, all those assets are still in your personal name when you die. So they go through probate anyway. You paid for the trust, but you never used it. That's such a waste. The only exception is for assets you acquire after your trust is set up and you forget to title to the trust. That's why we have a pour-over will. But the vast majority of your assets need to be actively transferred into the trust. Use your trust or lose the benefits of having one. 11, review your will. Life changes, so should your will. Here's another mistake families make. They create an estate plan once and then never revisit it. Life is dynamic. It's always changing. Your will and your trust need to change with you. Think about how different your life is from 5 years ago. Maybe you got married. Maybe you had children or grandchildren. Maybe your financial situation changed dramatically. Maybe you built a successful business or received an inheritance. Maybe you moved to a different state, which affects which state's laws govern your estate plan. Maybe you had a falling out with a family member you named as executor or trustee. All of these are reasons to review and potentially update your will and trust. You want your document to reflect your current wishes, your current family situation, and your current priorities. A will you created when you were 30 might not be right when you're 50 or 60. Your family changed, your values might have shifted, your financial situation is different. The best practice is to review your will and trust every 3 to 5 years, or immediately after any major life event. Major life events include marriage, divorce, birth of children or grandchildren, significant change in net worth, moving to a different state, health changes, or changes in your beneficiary's circumstances. When in doubt, revisit the document. An updated will reflect your current wishes. It prevents your family from following an outdated roadmap. It ensures your values are honored today, not frozen in time from a decade ago. 12, the legacy conversation, more than money. Here's the piece most people miss entirely about estate planning. It's not really about money. It's about legacy. It's about love. It's about making sure the people you care about most understand your values and how you want to be remembered. This is what I call the legacy conversation. It goes way beyond legal documents. It's you having conversations with your family about what matters to you. Share your values. Explain why you're leaving things the way you are. Tell your children stories from your life. Pass down your faith, if that's important to you. Share the lessons you've learned. Talk about your hopes and dreams for your family after you're gone. Because here's the truth. Money is temporary. Buildings fall down. Cars wear out. Investments fluctuate. But your values, your lessons, your love, those last forever. That's your real legacy. The takeaway is this. Share your values. Talk with your family about what you stand for. Talk with them about your hopes for their futures. Plan your legacy with intention. Leave peace, not problems. Leave wisdom, not just wealth. Leave love, not conflict. Your legacy is your love. Your values are your plan. Your intentions, clearly communicated and properly documented, are how you continue to impact your family long after you're gone. Conclusion. let me bring this full circle for you. We started by asking what happens to your assets when you die. Today, you now know there are 3 paths. And the critical realization is this: you get to choose which path your assets take. You don't have to leave it to chance. You don't have to hope your family figures it out. You can use beneficiary designations to bypass probate on retirement accounts and insurance. You can use transfer on death deeds for your real estate. You can create a revocable living trust to hold your assets and pass them smoothly to your family. You can draft a will that names your executor, protects your kids, and fills in the gaps. You can review your plan regularly and update it as your life changes. But here's what I want you to remember above everything else. Probate is not inevitable. It's avoidable. Family conflict is not inevitable. It's preventable. Unnecessary legal costs and court fees are not inevitable. They're optional, and I mean that in the sense that you can opt out. Every mistake we discussed today, dying without a will, failing to name guardians for your children, not updating beneficiaries, not funding your trust, leaving assets in your personal name, dying without a plan. So the court has to decide every single one is preventable. These aren't accidents, they're oversights. And oversights can be corrected with intentional planning. Here's my challenge to you. If you don't have an estate plan, create one. If you have an incomplete plan, finish it. And if you haven't revisited your plan in a few years, pull it out this month and review it. Update beneficiaries. Fund your trust. Have conversations with your family about your legacy. That's how you avoid probate nightmares. That's how you protect your family. That's how you leave a legacy of love and peace instead of a legacy of problems. Thank you for spending this time with me today. The fact that you listened to this entire conversation tells me you care deeply about your family's future. Take that care and transform it into action. Get your estate plan in place. Your family will thank you, and you'll have the peace of mind that comes from knowing you've taken care of those you love most. Until next time, take care of yourself and the people who matter most. I'm looking forward to connecting with you again soon.